In today's video, I will be looking at a 20 marker negligence question that I did in the progression exam. We'll be analysing the answer that I have done, and we'll be looking at how to plan your answer to a 20 marker negligence question. So the answer structure, I've been through this before in previous videos. You should have a brief summary, which is your introduction of the main legal issues. Then each paragraph should focus on a specific legal issue. You should have a topic sentence which links back to the main legal issue and it explains and introduces it. And then you should explain further, which will be part of your AO1, explaining the legal principle. And then you apply that legal principle onto the scenario, that'll be AO2, and you extend that AO2 further, giving you more AO2 marks or any counter arguments or any extended points. And then you'd do that with all of the paragraphs until you've gone through each of the main legal issues that you've outlined in your introduction, and then you finish with a conclusion, a summary of the main arguments you made in your answer, and you provide a clear answer to the question, which in this case would be liability. So here's the scenario. Pat was driving her car along a country lane and stopped it at a junction that joined a main road. The hedge next to the road was very overgrown and Pat did not have a clear view of the road. After waiting some time and no cars passing, Pat turned onto the road. Unfortunately, a cyclist was passing and Pat hit the cyclist with a car. The cyclist was badly injured and his bike ruined. Advise Pat whether the cyclist would be successful if he brings a claim in negligence against her. Additionally, you advise Pat whether she could sue the landowner for not trimming the hedge. So this is a very classic scenario, similar to the one case, Summer and Colborne. So as I'm reading through this, I'm thinking, does it seem similar to another case? And if they are, I'd try to remember what other case. So this one is very similar to that Summer and Colborne. And straight away I should know the answer. Would the cyclist be successful if he brings the negligence claim? Yes, he would be. And could she sue the landowner for not trimming the hedges? No, she wouldn't. Some people might end up getting the first part right, but would probably get the second part wrong, and they'd say that she could sue the landowner, but the landowner doesn't have a duty of care, which we'll see in the answer. So, when planning an answer, as you're reading through the scenario, you should mainly be thinking of the AO2. You shouldn't be thinking too much about the AO1, because the AO1 should already be memorized. You should have done enough past paper questions to memorize the AO1, and you should see a pattern beginning to form of which cases you repeatedly use, and the AO1, how you explain the legal principles and the introduction. And I've had mine memorized, and I wrote that down as fast as I could in the exam. And the only way you can memorize it is by doing past paper questions. That's the best way to memorize it. So, duty of care, case Robinson, establishing duty of care. Breach of duty, you explain that, and then you use Blythe v Birmingham Waterworks to explain the standard of care, and then you can do a further developed explanation by using another case, Nettleship v Weston, which is about the level of care of drivers. Then you can look at risk factors and then the different cases you can use to explain them. Damage, and you gotta give its explanation. And then you look at factual causation, legal causation, and the remoteness of damage, and you should know the cases for them. And then finally, to answer that second part of the question, you can use the case Summer v Colborne to explain how the landowner doesn't owe a duty of care, and therefore he can't be sued in negligence. So here's the answer that I wrote. I've done a brief introduction. So for the cyclist to be successful in a negligence claim against Pat, he should be able to establish that Pat owed a duty of care. She then breached that duty and that the breach caused the damage. So I've outlined the main legal points that I need to go over, that I will go over in my answer. Start off with duty of care, case Robinson. This will be your AO1 mark. This will be another AO1 mark when I explain. So here I explain duty of care. Then I explain Robinson, the case Robinson. Fair, just, and reasonable. That would be about perhaps 2 marks. 3 marks if the examiner's generous. And then in this scenario, it's clear that Pat owes a duty of care as she is a driver, as she owes a duty of care to other road users, as seen in various other cases. That's a bit of a short AO2. Definitely could have expanded here. Come back to it in the end to see if I could have expanded it in a way. Or in your answer, when you answer this question, you can expand on this. Next, they need to establish that Pat breached that duty. A breach of duty occurs where the tortfeasor fails to meet the standard of care required of them. AO1 mark. I then use Blythe v Birmingham Waterworks to explain the standard of care, and then I use Nettleship v Weston, and that would be worth 2 to 3 marks, probably 2. It would seem Pat had breached the standard of care and she didn't take more care, which a normal person would, as there was an overgrown bush obscuring her vision, requiring her to take more action, like slowly driving out until the bush wasn't in the way or honking her horn. This would be 2 marks because I extended it here. I developed the AO2. So I'd say Pat breached this standard of care. I explained why she breached the standard of care, and then I said what was required of her. What could she have done to not breach the standard of care? A normal person would sound the horn or drive out slowly, take extra caution because there's a bush in the way. So the judges will also consider risk factors like risk of harm, cost, and practicality. The case Haley v London Electricity Board explains that if the risk of harm is great, then the precautions taken need also be great. That's another mark there. Here the risk of harm was high as her vision of oncoming traffic was obscured, so she should have taken the extra care by slowly moving forward to check for oncoming traffic. That is AO2. And then for cost and practicality, it is clear that sounding the horn of the car and running forward wouldn't have been impractical. That's another part of AO2. I could have explained more for cost and practicality and got another AO1 mark, but then you have to judge up with the amount of time you have in the exam, and you need to make sure you're continuously going at a fast pace. So I'm not going to go through all of this answer, but if you want to use this answer as a model answer for your negligence question, I'll leave a link to this answer in the description below. So each one of my paragraphs, they go in a similar pattern. AO1, then AO2. AO1, AO2. AO1, AO2. And then I do an in conclusion here of the case against the cyclist. And this would be worth an AO2 mark. And then after a conclusion, I included, furthermore, Pat wouldn't be able to sue the landowner for not trimming, as it isn't required for them to do so, and therefore they owe no duty of care, hence they haven't breached their duty of care. A similar scenario occurred in the case Summer v Colborne, where the landowner wasn't liable for the overgrown hedge obscuring the vision of drivers. And this is also part of the conclusion, drawing the answer to a quick end, because you don't want to be spending too much time. This is the second part of the question, and you don't want to be spending too much time. Some people will probably spend too much time answering this part when it only requires a little answer because the landowner owes no duty of care in the first place, and therefore you don't need to go through each of the stages of negligence. You just need to look at the first one and show that he owes no duty of care, and you can use a case to get a couple of AO1 marks and a couple of AO2 marks. So now one thing that you want to remember is that your answer as a whole needs to look good. So you need to elevate every aspect of your answer to a level 4. Now, if you have one bad paragraph, the examiner will probably overlook it and give you 19 out of 20, 18 out of 20. But if your paragraphs if they all lack something, if they all lack some details or professionalism, then the examiner will obviously bring it down to a level 3, whatever they think it is. So you want to make all of your paragraphs, each and every single one, the best they could possibly be. And this means obviously doing a lot of practice questions until you get it, until you perfect it. So go ahead, try answer this question and make a model answer and perfect it until every paragraph is perfect. Get your teachers to mark it, get a 20 out of 20, and then use that as a perfect model answer, memorize the AO1, and then analyze the AO2. And you should be set for any 20 marker in the exam. So I'll see you in the next video.